Good morning. Thank you for moving up. We appreciate that. Ms. Angie, you may call the next case, please.
In re Estate of James A. Price.
Good morning.
Good morning.
May it please the court. I am Gordon Olswing of the Memphis-Shelby County Bar. I, along with my colleague Connor Ray, represent the appellate Kevin Price in these matters regarding the probate estate of Mr. Price's father, James Price. I ask for 3 minutes rebuttal.
3 minutes,
please.
all right, sir. You may proceed.
All right, thank you. First of all, if you were to read the record, you will see that we assigned probably 19 items of error for the probate court, Judge Townsend. Obviously, I don't have time to discuss all of these today. They're well drafted in our brief. What I would like today, if I have the time, is to address our allegations of breach of fiduciary duty by the appellee, Ms. Parker, against the estate's sole residuary beneficiary, Kevin Price, and against the estate itself. If I have time, then I'll try to move on to what we believe was error by Judge Townsend in awarding the appellee, Ms. Parker, attorney's fees, and then there are the other items. If I can get to them, I will.
Let me ask you a question before
Yes, sir.
we get too far into this. I note that at some point, the appellee was ordered to pay $18,000 of the fee to Attorney Thompson. A motion to alter or amend was filed. And I can't tell from the record if that motion was ever resolved.
Well, I can tell you this, and excuse if I can't remember the record because it's quite extensive. I will tell you this. Ultimately, the probate trial court judge awarded the administrator CTA's fees, Ms. Tom, I believe $33,000, and she charged all of that to the estate. Now, the problem with that is charging all that to the estate is my client, the appellant, Kevin Price, is the estate's sole residuary beneficiary. So as a practical matter, any dollar that is paid by the estate is actually a dollar out of my client's pocket. So
I understand your reasoning. What I'm trying to do is figure out if we got a final judgment.
Well, we believe the final judgment was an order of $33,000 against the estate.
Was this matter?
There was so much going on the record, if you check, is that first Judge Townsend made a lot of rulings without any hearings whatsoever. He then completely reversed all his rulings and said, we're going to have hearings. One of those rulings at one point was $18,000. I will tell you the final ruling was, I believe, an award of $33,000 to Administrator CTA Thompson.
Well,
of which
I don't want to waste your time today, but if you would check it, and both of you please check it. We need to make sure we got a final judgment here. We got a lot of moving parts, and
I can answer that when it's my turn, Your Honor.
okay, that'd be fine. Thank you. Again, I don't want to waste your time with all this. So go ahead with your argument. I'm sorry.
All right. Your Honor, first I want to address the matter of breach of fiduciary duty. Judge Townsend, we alleged, or the appellant Kevin Price alleges, that the appellee, Ms. Parker, breached her fiduciary duties both to Mr. Price and to the estate itself. And we believe those breaches of fiduciary duties were extensive. And the judge erred, trial court erred, in finding that she committed no breach of fiduciary duty, and also finding that her acts, which record is clear, I'll discuss some today if I have time, is that her records were, hey, there were nothing more than negotiation. Now, what we allege is the judge got it wrong. He erred big time, allowing or justifying a fiduciary's bad acts as acts of negotiation completely negate a fiduciary duty from acting appropriately in regard with their fiduciary duties. And he gave no reason. He ignored all the bad acts of Ms. Parker. He gave no reason as to why negotiation or couching and action is negotiation, somehow negates the duty to act right, somehow changes the relationship between the fiduciary and the estate's sole residuary beneficiary. And it's really clear here. And frankly, if I'm summing them up before I get to the detail, is Ms. Parker started, the estate was ready to be distributed on March 18, 2020. There was a lot of the residuary estate consisted of cash of a couple $100,000, but about $1.4 million in real property, rental properties, about 30 properties plus. Could have been some more, but about 30 properties. Those properties should have been distributed outright according to the term of the will, but they were clearly ready to be distributed on March 18, 2020. The record is clear. Ms. Parker said there was no reason they couldn't be distributed, but she refused to distribute them. She refused by her first letter in writing that said, through her attorney, is I'm not going to distribute the property. I'm not signing the deeds, even though they're ready to be signed. I'm not going to sign. I'm not going to convey the property to you until you agree to my fees. That is clear. And by the way, if you were to read the judge's final order, trial court's final, he didn't even talk about this March 18 correspondence in which Ms. Parker says, I'm not distributing the property to you unless you agree to my fees. Now, there's a second letter written immediately after that. That letter is, I'm not going to distribute the property. I now want you to share in the estate with me. Share in the estate. She had no right to share in the estate, but share in the estate to the amount of $500,000. As a practical matter, she is asking for, oh my God, extremely excessive fees at this point, and she's asking to share into the estate. So you read these first two pieces of correspondence together. She is saying, I am not going to distribute the property to you, which is ready to be distributed by all accounts, unless you pay me $500,000 in addition to the specific bequest I'm going to have. In other words, $500,000 plus specific bequest for probably about $300,000. $800,000, that is pretty much half the estate. So we're saying first that the mere fact of asking for the $500,000 to share in the estate is a breach of her fiduciary duties. And now let's remember what some of these duties are. One of the primary duties is that a fiduciary, an executor of the estate, has to deal with the estate's residuary beneficiary with the utmost good faith. Not just good faith, the utmost good faith. That is the highest good faith. That is to the best of her ability, to the best of her resources, she has to deal. So asking to share in the estate, which she is not entitled to, is certainly a breach of the dealing with the utmost good faith. One of the other primary duties of an executor is, you know what? You got to carry out the terms of the will. You have to sustain the will. You can't change the terms of the will. And when she asked to share in the estate, when the will didn't provide for any of that, in addition to her specific bequest, that is definitely a breach of fiduciary duty. She is now trying to fundamentally rewrite the estate. Now, in these two letters, where I'm not going to give you the estate, I'm not going to distribute the property to you unless you give me $500,000, by definition, that's ransom. It is. You're holding the property ransom unless you get what you want, which you're not entitled to. That is ransom.
And the damages to your client?
I'm
was
sorry?
what? And the damages to your client?
The damages to the client were anything but slight, because imagine what happens. My client gets a letter. They're significant, Your Honor, to answer the question directly, but now let me tell you why. Is he gets this, he's entitled, he asked for the property, $1.4 million, to be distributed to him. The co-executor of the estate says, no, not signing the deeds, not going to do this. So what's the first thing he has to do? Is when she asks for excessive property, when she's asking to share in the estate, all these things she's not entitled to, first thing he's got to do is go out and hire me, because he wants his property. Till that time, he did not have an attorney. To that time, he didn't need an attorney. But once she embarked on these actions of a self-interest, he had to go get an attorney. Now, then it continued, because understand these breaches continued through the whole thing. The estate was open on March, I might be off a day, but November of 2018. Okay, I think Mr. Price died on November 18th, and I believe the estate was open November 27th, 2018. I sort of remember that because that's the date of my birthday. This estate then is open for at least 16 months to March 18th. Now, there are a couple of things that happened during that period of those 16 months up to March 18th that we'll discuss. For example, the payment of Florida expenses should have been paid, the property could have been distributed. But the real breaches of fiduciary duty didn't start until March 18th, 2020. And so he had to hire me, and his fees were $150,000, and I'm not that expensive, and I have a light pen, but because they continued to thwart the closing of the estate. Now, one of the things they did besides those first two letters, they write a letter that says, you know what, if you don't agree with us, we're going to cost you a lot of money. So they go from ransom to extortion, because that's what it is. I'm going to cost you a lot of money if you don't agree with me. That's $150,000 a unit. So the damages were anything but slight. The damages were expensive. But the breaches continue on. Now the estate, to close a probate estate, former chancellors, y'all know, you have to take care of all the administrative expenses. You got to pay, all the fees and everything. The first time that the appellee Parker filed anything formal for a fee was in, I believe, October of 2021. All right? October 2021, that is a year and a half after March 18, 2020, when things are ready. The record is clear. The appellee, Parker, says she had no duties after March 18, 2020. She could have distributed the property, could have filed a petition for fees, would have closed the estate. Now, she gets her money, but they're just not closing it. Now, if you read the record, there are 3 reasons why they said they couldn't close. One is because they claimed that Mr. Price took personal property that they couldn't identify, but they said he took it. And they actually file to get this mysterious property back. When you go to the record, you will see she can't prove this property ever existed. And I believe the testimony was, I asked her at one point in deposition, is when you say it's possible that this personal property that you can't identify exists, I said, is it possible that it exists, or is it possible like the sun won't shine in the morning? Her answer was, it's possible like the sun won't shine in the morning. That was one. Then they offer the excuse, well, we can't close because that will, it provides a 2% fee issue, and we don't have that information for the 2% fee. And very quickly, anyway, 3 reasons is that she kept the estate open the whole time. There was ransom, there was extortion, there was undue delay. The record is clear, and for the judge to say, oh, it's okay for you to try to unduly profit from the estate. It's okay for you not to treat the beneficiary with the utmost respect. It is okay for you not to carry out the terms of the will, because all you got to do is say, hey, you know what? It was under negotiation. And I would suggest to this court that when
Used your time.
I would suggest to the court.
You've used your time.
I'm sorry, Your Honor, it was still showing, excuse me.
That's okay.
Thank you very much.
May it please the court, my name is Matthew Thornton. I represent the appellee, Judy Parker. Judge Stafford, as a preliminary matter, I wanted to address your question. There were 3 motions to alter or amend that I filed in February of 2023 addressing the order that you referenced. Judge Townsend, in his April 20th, 2023 order, which I believe is one of 3 orders, specifically set aside that order requiring my client to pay $18,000 of the successor administrator's fee. So that, I believe, is a resolved issue.
Okay, thank you.
Judge Townsend wanted to hear everything anew and gave us a trial date. Does that
Yeah,
satisfy?
that's fine, thank you, I appreciate that information, I just couldn't find the order.
Your Honors, pleasure to be with you today. Judge Armstrong, good to see you. It's been a long time. I wanted to give you an overview of where we are and why I think, despite the hair on fire allegations that the appellant makes in this case, the judge saw through that. First and foremost, I'd point you to the correspondence that comes from my office, that came from me specifically, that's attached to the appellant's brief. In there is a reference to a lot of money as far as costing a lot of money, but it's not a threat. It basically says, it certainly saves everyone a lot of money if we're able to work everything out. That's not me on behalf of my client threatening to cost the estate a lot of money. As anyone who's done probate knows, that to resolve an estate fee issue, there's one of two things that can happen. You can either have an agreement of the parties, which we were unable to reach in this case, or there has to be a court hearing and a ruling on fees. It's the only two ways to resolve an administrative fee question. Now, there is some question as, well, the decedent died in 2018. Why did we not have the trial resolving that matter until August of 2023? And was my client, Judy Parker, responsible in any way for that delay? Your Honors, everything proceeded very smoothly in this estate until March of 2018. 2020. The decedent died in November of 2018. There was really very little dispute up until March of 2020. That's when I got involved on behalf of Ms. Parker, and Mr. Olswing got involved shortly thereafter. I believe it may have been April or maybe even March of 2020. That's when things went south. In March, prior to Mr. Olswing getting involved, his client stated in an email to the estate attorney, Susan Callison, that my client had been very diligent. She used the word, she had administered the estate diligently. Not more than 2 months later, in May of 2020, he alleges breach of fiduciary duty for the very first time in a pleading. And so we've been defending ourselves against that allegation and other allegations since that time. The decedent is a gentleman named James Parker, referred to as Jim. He and my client were long-term, had romantic relationship for 27 years. In his will, he left certain things to my client, and the residuary, certain specific items to Mr. Olswing's client, and then the residuary to Mr. Olswing's client. My client was given the tangible personal property defined in the will under the defined term of personal and household effects. My client was also given a condo in Florida, and my client was given a $50,000 bequest. The way he set the will up, he wanted my client, who was a local Memphis resident, and Mr. Price, who's Mr. Olswing's client, to serve as co-executors, because he knew that Mr. Price lived in Virginia and would need help with the 30 rental units that he owned at the time of his death. So my client basically, for that two-year or 1.5-year period of harmony, did everything that Mr. Price asked her to do. She was his go-to person on the ground. She visited these properties. She was his eyes on these properties. She related to him pictures and emails sending back so he could remain in Virginia. He worked full-time in Virginia. And at the end of that period of time, they came to a dispute as to fees. And so that's when Mr. Olswing's client began to take a very defensive position. And ultimately, his most recent sworn pleading not only said my client was not entitled to a fee, but for damages, my client would end up, according to him, paying him $1.4 million in both punitive and compensatory damages for the privilege of having served him faithfully for 1.5 years on her long-term friend's estate, his father's estate. We think that's manifestly unfair. Now, Mr. Price is the kind of person that I classify as a bully. I called him that in trial. I'll call him that today. He's a bully. He negotiates everything. He wanted to negotiate the credit card debt of the decedent. He wanted to negotiate the fees of the CPA. He wanted to negotiate the fees of the estate attorney. And so my client knows him for over 27 years, and she knows his propensity. So yes, we asked for a large number. We asked for $300,000. That was in addition to what we were already getting under the estate. We asked that in an offer of judgment dated April 21st, 2020. So again, you can see, March, he says she's diligent. He gets the demand in April of 2020. And then in May, he alleges my client has committed breach for the first time. Ultimately, the court, Judge Webster, set several hearings, and that's one thing I wanted to be very clear about. Judge Webster was the Division II probate judge at the time. When the dispute arose, it's March of 2020. Well, of course, March of 2020 is the very onset of the COVID situation. Judge Webster was very concerned about COVID, and her office and access to her became very limited at that point. So we had trials or hearing dates set in 2021 and 2022 that were not fulfilled because of COVID. Mr. Olswing himself had filed a motion for an in-person hearing. We felt it was far too complicated, and the witnesses and the case was too complicated to be heard via Zoom or telephonically. And so we had asked, we both desired an in-person hearing. The final hearing that would have gone forward was August of 2022, and then Judge Webster was defeated in the election. And so therefore, we didn't hold that hearing because Judge Townsend was coming in. So we had a trial then set for February of 2023. Judge Townsend canceled that hearing and issued those rulings that we've discussed earlier that he since overturned. So the very first date that we could get a court to weigh on multiple issues in this estate was the August 2023 trial in front of Judge Townsend. There was four main things that we're fighting about in this case: tangible personal property, the timing of distributions, the breach of fiduciary charges, and the fees. Those are the primary areas that we're arguing about. When my client removed the contents from the decedent's home, the home had been left to Mr. Price. When she removed the contents from the home, I think that triggered Mr. Price because he had already, without her knowledge, removed some of the items. Now, Mr. Olswing asked her, what did she take? And when she couldn't, because she had not been present in that home, and Mr. Price had had full access to that home, she didn't know what had been taken. But it's very clear in the record that of the list of items that were required by Judge Townsend to be returned to the administrator of the estate, and is currently being held by the administrator of the estate, they're only arguing about a handful of the total number. In other words, they've dropped the argument that these other items that he took, that they're claiming, because they know that that's a losing argument. But those items were not returned, and therefore the estate was not ready to close until that August 2023 hearing, and the court ordered them to return those items, which he had taken from Memphis and taken to Virginia and refused to return. Mr. Olswing mentioned the timing of the Florida distribution. As I mentioned to you, my client was the beneficiary of a Florida condo. That probate administration in Florida was not initiated until March or April of 2020. Again, the decedent died in 2018. The will says specifically that all property that's gifted under this will remains as a part of the estate, and the ongoing costs are maintained and paid by the estate until they're distributed. Now, obviously, the will contemplated that they would be distributed quicker than they were, but the question is, why weren't they distributed when they were distributed? The answer lies solely with Mr. Price. My client, as a non-relative, unmarried partner, had no right and no authority to initiate probate in Florida. That was confirmed by Mr. Huff, the Florida attorney. So the onus rests solely with Mr. Price to initiate that. He failed to do that until April, and then wanted to look back and say, well, Ms. Parker's been enjoying this property for 2 years. She should pay us those 2 years' worth of expenses. We denied that because it's not on us to transfer that property. It's on your client to do so. Why would we bear the burden of paying those expenses for your negligence in getting it done? Now, the estate attorney, Ms. Callison, did bear some fault in that. She acknowledged that fault. But that's not my client's responsibility. She had no right, no legal duty to have probated in Florida. So the timing of the Florida distribution is not at issue in our minds. Then the issue of the distribution of the property in Memphis. Much is made about our refusal to distribute that property. And again, if you look at the correspondence attached from me to the appellant's brief, the only thing I would ask you to do is, as part of the trial on the third day, I got in 3 more attachments that supplement that. In the rule of completeness, I argued that, hey, if you're going to introduce my response to his email, you need to introduce his email. Those are exhibits 41, 42, and 43 from the trial, which are in the record. And what they show is that Mr. Price was very intemperate in his responses and his demands. And so my responses are measured accordingly. Now, they're always professional, in my opinion. They're always polite. But they do throw out a large number that I believe my client's services were worth. It was not a demand, and it certainly can't be a ransom, because if we don't agree, then the only other way to resolve this is by court hearing, and that didn't occur and couldn't have occurred until August of 2023. So there's no way to lay any of the, quote, delay in getting the estate closed at my client's feet. Absolutely impossible to do that. There was nothing she could do. In fact, when our clients were removed and a new administrator was put in place, she didn't close the estate. There's been another administrator appointed. He hasn't closed the estate. Why? Because these issues of the return of the personal property that Mr. Price took had not been resolved. The fee issue had not been resolved. So if Mr. Price, again, is concerned about the length of time in the estate, he could have negotiated with us, and I'm sure it would have ended up less money out of his pocket had he done so. But he didn't do that. Much has also been made about a refusal to sign deeds. And Mr. Olswing goes to great lengths to say there's nothing in the record as to why those deeds couldn't have been done March of 2020. The answer to that is the deeds weren't drafted until April of 2020, and in April of 2020, my client signed those deeds. There was no delay between the preparation of those deeds and my client's signature on those deeds. Now, was it imprudent for me, as the attorney advising my client, to allow those deeds to be done, knowing that that reduced the value of the estate and it might result in an inability of the estate to satisfy my client's ultimate fee award? It was, but to keep the peace, we had done that. But there was no delay in Parker signing those deeds. Justice Cardozo is famous for his Meinhard v. Salmon quotation regarding breach of fiduciary duty. Much has been made by the appellant in this case regarding breach of fiduciary duty. He alleges that the mere asking for a large fee is a breach of fiduciary duty. We did not ask for that large fee until, again, April of 2020, and it was certainly rejectable by the client, which his client did reject, and we ultimately had a hearing on that. But again, during the administrative process, he said our client had been very diligent, and the court found that she had been intimately involved in the rehab of the 30 rental properties, dealing with insurance, paying bills, and the appellant acknowledges those things and yet still says that my client committed a breach. I would argue, and we didn't hold him to this, but the secreting of property that belonged to my client to Virginia was a breach because he did that when he was co-executor. He owed that high duty to my client, and we did not try to call him on that breach, but it's interesting to me he's arguing breach. Finally, Your Honor, In re Estate of Wallace allows for an executor who's been falsely accused, wrongly accused of breach, to recover attorney's fees from the estate. We believe the judge saw that in this case, saw that my client did not commit any breach, and therefore was not, should not be responsible for having to cover the cost of defending herself from unfounded charges of breach. And we think that also can apply to this appeal, and we would ask the court to continue to allow her attorney's fees for defending herself here.
Let me ask you, the fee awarded, does it exceed, and I know that the 2% is not the max, that's just the floor. Does it exceed 2% of the gross estate. Was that ever determined?
It was never determined specifically, Your Honor. One thing that was not acknowledged was the fact that, and this is, I'm getting a little complicated on you, and I'm a nerd, probate nerd, but Mr. Price, the items he got in Section 1 or Article 1 of the will didn't count toward that value. But the house had been left to the daughter who had died predeceased, and therefore the house came in under the residuary estate. So therefore, not just the rental properties counted toward that 2% calculation, but also the decedent's home, which was of value as well. We never came to any agreement on what that value was or what that number was. It does say floor, and that was our argument. It does say it's just a floor, it's not a ceiling. Our argument was, this lady has served you so well that the 2% is a slap in the face in essence. She deserved more than that for what she did. And also the valuation, just to be clear, was set by the Mr. Price himself in a lawsuit that they were defending as co-executors. He valued her time at $95 an hour. So the judge said 1,200 hours at a minimum she worked times 95 gives us the fee that we were seeking.
Thank you.
Thank you.
Thank you. If I may proceed, a couple of things.
Certainly.
Number one,
But
classifying.
Before you start, though, following up on Judge Armstrong's question, I know you're challenging the fee award, but are you challenging the award itself, or are you challenging the amount, or are you challenging both?
Both. You're talking about the attorney fee award?
Yes, sir.
Both. First of all, look at their motion for fees. It is specifically related to the accusations of a breach of fiduciary duties, all right? Number one, I don't think there was a formal breach of fiduciary duty claim filed until December of 21st. The first time they filed their petition for fees, of course, we filed a counter-complaint, and that counter-complaint included a breach of fiduciary duties. And I think they filed their first fee petition in October 2021, and we filed a response to that in December of 2021. So we're going for both. First of all, the fee itself is supposed to deal with accusations of breach of fiduciary duty. Look at all the things that had nothing to do with breach of fiduciary duty. If you read that motion, it says, we have incurred $68,000 of fees since I hired the attorney. Doesn't say what it relates to. First of all, the $68,000, that includes their fee request in the beginning. It includes those letters which we say are inappropriate. When Judge Webster removed the co-executors, Mr. Thornton dealt with that. So his fees over all this time have nothing to do with breach of fiduciary duty. They have to do with administration requesting fees, have to do with the administrator Lynn Thompson's accusations against them, has to do with the removal of her as a co-executor. You will see all that. Second of all, the American rule of law prevents it. But even more so, there is not any evidence that his fees were fair or reasonable because we never saw an invoice. The judge didn't desire invoice. So right v. right requires to determine whether a fee is reasonable. Those 10 factors the Supreme Court sets forth in its Rule 1.5, I can't remember the exact rule, the same 10 reasonableness factors. None of those were discussed. The judge just said, all right, you're asking for $68,000. I'm going to give you $68,000. It made no sense, and frankly showed a biasness. And number two, in the 20 seconds, he classified my client as a bully. He also said my client didn't do anything wrong until March 18, 2020. They were doing fine. If he was a bully, why didn't he start bullying before then? He only hired me, and I became his bully, is when he asked for his $1.4 million in property, and their first response is, you're not getting it. I'm not going to give it to you, and I'm not going to give it to you unless you're sharing the estate with me. Then he got concerned. So to classify him as a bully is wholly unfair because by his own statements, everything was working fine. And again, I ask that you read the record because She acted wrongly. She acted poorly. She acted contrary to her duties, and thank you very much.
Let me ask you, the $90,000 fee, does that exceed 2% of the
It
gross
does.
estate?
In fact, the
What was the
record
amount
show,
of the gross estate?
we figured the 2% was probably about $41,000 at most, but she wasn't entitled to that, because if you read the record, she didn't. It is very clear by her own testimony. Number one, this property could have been distributed outright. She says so. Number two, she says she only gets to 2% if she has to dispose of the property. I can't remember the exact language without that in front of me. She didn't have to. She testified she didn't have to. She testified that she dealt with the property as a moral obligation. And yet, somehow, that moral obligation, she is asking for $500,000. You know, but the record is clear. She didn't have to be involved. When the property finally got distributed on the 21st of April, she wouldn't need it. There's a professional management company. So to say one day she is absolutely necessary and the next day she's not necessary, she was never necessary. She didn't have to be involved.
When you say it was not necessary, are there provisions in the will that have provided for her to take control of all of this property, pay expenses and everything in connection with this property until it ultimately was distributed?
No, not really. She was
When you
appointed.
say not really, what does that mean?
Because I'm not clear of exactly the question, so I'm going to answer it the best I can, Your Honor. The answer was she was appointed as co-executor, but there's specific provisions that says you're only going to be paid if your services are necessary, essentially, in the 2% fee paragraph, and her services weren't necessary. There is a professional management company. She wasn't required. Professional management company is still managing those properties. It managed it still, and if you go through the record, there's a listing of things that the management company did that she wasn't involved in, and yet this judge, the trial judge, they're asking for, if you read the numbers, the professional management company was paid $30,000 over the same period of time that Ms. Parker is asking first for $500,000, then for $300,000. She is being paid. She originally is asking $409 an hour to read emails and go to the post office every single day. Then when she changed it to $300,000, that's still $250 an hour to read emails and go to the post office every day. And just one more thing, when you read the record, thank you.
Gone way over.
Thank you, Your Honor.
And I will tell both of you, there have been several references to, if you will read the record, I assure you, you're not going to find anybody who reads the record any more closely than we do.
Your Honor, we're aware of that.
If that's a concern, don't let it be.
No, just, Your Honor, it's a safe
I
way
understand. No need
to
reply.
respond.
I'm just saying,
Thank you.
don't ever think we don't read the record. We'll be in recess till the call of the afternoon docket.
All rise.
Judge Armstrong, good to see you again.
Good to see you.